Good afternoon, everybody. Welcome to the Labor and Employment Regional Law Update for the East Coast. It's now my pleasure to introduce today's presenters, Connie Montoya and Andrew Gordon. Connie Montoya, a partner in our New York and New Jersey offices, counsels her clients on a variety of employment issues, focusing on discrimination and harassment matters, including claims relating to discrimination on the basis of ethnicity, gender, age, pregnancy, and disability. She has defended employment claims before the federal and state courts, as well as administrative and governmental agencies, including the EEOC and the FLSA. Andrew Gordon, a partner in our Fort Lauderdale office, represents employers in federal and state courts, in arbitration, and before government agencies on issues involving discrimination, harassment, and retaliation, wage and hour, FMLA, ADA, and other federal, state, and local leave obligations. Okay, Andrew, take it away.
All right, thanks for that introduction, Stephanie. And by the way, AG, those are my initials, but I have no associations with gorillas, but those are my initials. Connie, great seeing you. Connie and I love doing this presentation together. We've done it a few times now because it's a good way to show the difference in business environments between two very important states for our national economy. As you all know, Florida and New York consistently rank as two of the biggest economic engines in the US, but interestingly, they go about how they create business environments very differently. Not to say one is right or one is wrong, I'm biased towards Florida, but they both have a way of governing businesses in their states, and it works for both of them, and you'll see that dichotomy today. My presentation is going to focus on Florida, and Connie will obviously focus on New York. The goal of my presentation is to make you aware of recent changes here in Florida and to help you comply with these changes. And right now on your screen, you can see the agenda, all the topics I'm going to cover today. These are all the hot button laws that came out of Tallahassee. And we're going to talk about some things we think are going to happen this year in Tallahassee as well. So with that, let's go ahead and get started. Next slide, please. All right, first up, if you could go back one slide, Stephanie. We're going to talk about E-Verify, but before we get in to the meat and potatoes of E-Verify and this new change in Florida law, let's just talk about what E-Verify is. Most employers are at least somewhat familiar with this, but E-Verify is a free internet-based system that employers can use electronically to confirm employment eligibility of employees. E-Verify takes information entered by an employer that an employer gets from a Form I-9 and compares it to records available at the federal level to confirm that an employee is eligible for employment in the US. Who was using it before Florida required it? Federal contractors and subcontractors and employers required by state and federal law. And now Florida joins 9 other states who mandate E-Verify in some form or fashion. Next slide, please. All right, so you probably have heard as of July 1st of 2023, if you're an employer with 25 or more employees here in Florida, you got to use E-Verify to confirm the eligibility of employment of all of your new employees. This only applies to new employees. And I've been asked a lot, why was this enacted? What was wrong with the old system? And that's a tough question to answer because this is where you see how politics drives legislation. It's said that this law in Florida was enacted in part as a pushback against increased illegal immigration that's taken place over the last few years in the US. And interestingly, politicians here in Tallahassee thought this would play well to their base, but there was almost an immediate backlash against this law, particularly in industries like construction, that thought as a result of this law, there was going to be a massive negative impact on the pool from which they could pull workers. Now, we haven't necessarily seen that yet. Anecdotally, there have been stories of worker shortages in certain industries here in Florida. I think we're going to have to wait a bit longer and see what the data proves in time. But again, if you are an employer with 25 or more employees, you now have to use E-Verify. The old way of doing it is no longer acceptable, and you've got to use E-Verify. Next slide, please. And as you'll notice, enforcement, including penalties for non-compliance, is not supposed to start until next year, which is good. It appears the legislature recognized that this was going to be a big change for a lot of businesses and has given those businesses as much runway as possible to make this switch. But I do want to point out that there have been reports that the state's already sending out audit notices. So there's certainly some confusion right now about when penalties might be enforced. Even though the law says 2024, it's odd that audit notices are already going out. So it's best to go ahead, if you're subject to this new law, to get things lined up now instead of later. And you'll see these penalties are pretty stiff, and they're some of the toughest in the nation. So it's really imperative that you take advantage of what is supposed to be this grace period until July of next year and get your systems up and operating as compliantly as possible. Next slide, please. All right, here are some of the best practices to do that. First, you got to figure out if you're even subject to this new law. And again, 25 or more employees, you're subject to it. Under that, you're not. Go ahead and enroll with E-Verify, get familiar with the system, and make sure you're talking with your human resources team to make sure they understand this law. And something that's not up there that you might want to look into is determine whether there's any third parties out there that might be able to help you with this law, and maybe even to whom you could outsource it like you do certain HR functions like payroll. All right, so that's E-Verify. Let's go ahead and move on to the next slide, which is Florida minimum wage. So there seems to be a huge national trend towards increasing minimum wage in certain states. And arguably, this is something states are doing to attract certain workers and segments of the economy where it's getting more and more tough to find real talent. This is something that's been in the works for quite some time in Florida, and we just want to make sure you're caught up and in the loop. Next slide, please. So here you see what the increases to Florida's minimum wage are and will be over the coming years. These increases are meant to be relatively minor and incremental in order to help businesses absorb these new costs to doing business in Florida. And just an interesting note, for whatever it's worth, there's currently 16 states with a higher minimum wage floor than Florida. And those current minimum wages range from $12.60 an hour to $17 an hour. And you'll notice in 2027, the adjustments are no longer going to be made on a dollar basis every year. They're going to be made at the rate of inflation. Thankfully, this is going to be tracked by the state, the Florida Department of Economic Opportunity, and they're going to be responsible each year on an annual basis to let employers know what that increase based on inflation will be. So that's not something employers are going to have to worry about. Next slide, please. Now, it's important to note that this new law applies to all non-exempt employees. So it's a law that overall should be easy to comply with, and one that hopefully will increase employee morale without too much of a negative impact on employers' bottom lines. Next slide, please. All right, COVID in the workplace. So it's been 3 years since the pandemic began, and it's almost close to a year now since the federal government declared the public health emergency associated with COVID to be over, but we're still talking about COVID in the workplace. But now the conversation's less about how to protect against COVID and more about the fallout from COVID and vaccination status in the workplace. and what employers can and can't do when it comes to requiring employees to get vaccinated and or to take mitigating steps to prevent the spread of diseases in the workplace. Next slide, please. All right, so the Medical Freedom Bill passed last year in Tallahassee is a law that prevents employers from discriminating against individuals. This includes employees and applicants based on vaccination or immunity status. Employers can't require any person coming into their business, employee or customer, to present proof of vaccination or to submit to a COVID test to come into their business. And except for healthcare workers, employers can no longer require a person to cover their face or use any kind of facial covering in general that covers their nose or mouth in order to prevent a perceived spread of a disease in the workplace. This was part of Governor DeSantis's efforts to fight against what he and the Florida legislature perceived as overreaches by the federal government. And it is a pretty all-encompassing law that has pretty big implications in most businesses here in Florida. Now, I do want to point out that this law applies to any disease, not just COVID. That's why this is relevant. Even though the pandemic is over, this law is meant to cover any communicable disease that currently exists or could exist in the future, which is why we're talking about this today. Next slide, please. Now, these penalties are big and powerful, and I think that's a result of some of the politics associated with this particular issue. And you see them up there on your screen. $5,000 per violation and reinstatement of employees who are terminated as a result of some of the things we're talking about today. Now, one thing this law doesn't talk about is that it likely contradicts or will contradict potential laws or existing laws that come out of DC relating to workplace safety in the face of communicable diseases. So it's very possible that this law will eventually be challenged due to it being preempted by federal law. But in the meantime, employers need to be aware of this state law and comply with it unless they have reason to believe it directly contradicts an existing federal law, in which case you should consult with your attorney before making a decision on whether you're going to comply with the state law or the federal law. Next slide, please. So unless your business is subject to a carve-out, for instance, like certain employers in the healthcare space, your policies relating to COVID protocol and protocol associated with any illness in the workplace needs to be reviewed to ensure it complies with this law and that they do not include policies regarding masking, testing, or vaccination that conflict with this new law here in Florida. Next slide, please. Florida preemption law. So Tallahassee's gotten very aggressive as it relates to preemption laws over the last few sessions. In fact, our local NPR station here in South Florida has a whole podcast on this issue, how Tallahassee's really taken the teeth out of local laws at the county and city level across the state and really usurped that power and taken it back to Tallahassee. So these laws, as they relate to rules in the workplace, are said to be made, this preemption law is said to be made in order to create a consistent and cohesive environment from the Panhandle to the Keys and everywhere in between, so that businesses can operate with one set of rules instead of 67. I use that number because there's 67 counties in Florida and literally hundreds of cities which could make their own rules for employers that make it difficult for employees to operate here. So this is another example, arguably, of Florida trying to promote itself as one of the easiest places to do business. Next slide, please. So again, this law is meant to make it easier for businesses to try and strike down local laws that are inconsistent with state law, and that would create two sets of rules for businesses to follow. And this preemption law gives businesses a clear roadmap on how to challenge these local laws, whether they be at the county level or city level. And what's interesting is this law requires an immediate injunction to be granted as soon as a challenge is made under this law, immediate, which is very different than how traditional injunctions work, where the parties typically have to present their case to a judge in order to get a temporary injunction. And that process, as everyone knows, can take quite some time, sometimes weeks, sometimes months. But this law says as soon as a challenge is made, an injunction is to be granted, preventing the enforcement of that local law at the county or city level that's inconsistent with the state law. And another thing that's worth pointing out is this law allows a successful plaintiff, a successful business or an individual to recover up to $50,000 in attorney's fees for bringing a challenge to a local law or ordinance. And this removes what has historically been a pretty big barrier to businesses, particularly small businesses, from challenging local laws that they think are hurting their bottom line. Next slide, please. Now, up on your screen, you can see the exemptions to this preemption law, and they're pretty narrowly tailored and really aren't likely going to slow down what I think will be an increase in businesses going pretty aggressively after local laws that they don't like and that they think hurt their bottom line and contradict current existing laws in Tallahassee. So I do anticipate that this is going to be a big issue in Florida over the coming years, and I think it's going to create a whole niche area of law in terms of litigation. I think you're going to see a lot of businesses and individuals stepping up to try to push back local governments from restricting how they do business. Next slide, please. And again, the anticipated impact, at least what we're told from our legislators in Tallahassee, is that there should be a consistent and cohesive framework based on one set of rules here in Florida for businesses to conduct themselves. This is, again, supposed to result in yet another tool in the toolbox for Florida to attract and retain employers, but it's certainly going to come at the expense of local government and local control. Next slide, please. All right, Florida's Stop Woke Act. This is one that's gotten a lot of national attention since this law was passed in 2022, and I suspect most of you have heard about this law. Arguably, this law was a bit ahead of its time. It was passed at a time, 2022, when the pendulum had swung pretty far to one side in favor of DEI-related initiatives. And now that pendulum is currently swinging the opposite direction as we see a bit of a pushback against DEI initiatives from coast to coast. Next slide, please. Now, I'm not going to go into all the detail about what the Stop Woke Act bans, because it's a pretty long list, and it's going to be on the next few slides, so you can read it there on your screens. But essentially, it prevents employers and schools from requiring employees to attend certain types of DEI-related trainings that endorse concepts that are banned by the Stop Woke Act. And I'm going to show you what some of those concepts are on the next few slides. So next slide, please. So here are some of the concepts. There's 8 of them in general. 3 of them are on your screen now, and a lot of you have heard me talk about the Stop Woke Act before, so this shouldn't come as a surprise to you. Let's take a peek at the next screen. Here's some more, 3 more of the concepts banned by the Stop Woke Act. And then our next screen are the 2 final concepts. And while you're finishing reading this slide, I just want to make clear that the Stop Woke Act doesn't ban DEI training. It just bans DEI training that endorse these 8 concepts that you just saw on your screen. But you can likely see how tough it would be to conduct a DEI training that doesn't at least touch on some of these 8 concepts you just read on your screen, which is one of the difficulties in the enforcement of the act and why it is currently subject to a pretty big piece of litigation that I'm going to talk about on our next slide. Next slide, please. So again, the Stop Woke Act went into effect in 2022, but it is currently subject to a temporary injunction that was entered by the U.S. District Court judge overseeing this case. So even though this law has been around for almost 2 years now, it's currently unenforceable in Florida while this piece of litigation plays itself out. And we suspect this piece of litigation, once there is a ruling one way or the other, will likely be appealed. So it could be quite some time before the Stop Woke Act goes into effect in Florida or is deemed unenforceable altogether here in Florida. But I do want to point out that since this law passed, we've seen a trend at the national level, like I alluded to earlier, of DEI-related initiatives taken a big hit. So there's a Supreme Court banning certain types of affirmative action and admissions, certain Ivy Leagues being under the microscope and losing their leaders because of issues, at least in part relating to DEI, and even wealthy private citizens suing law firms with DEI initiatives and coercing those law firms to scale back those DEI programs. So the point of raising all of this is to say, even if the Stop Woke Act is shut down in court as a result of the lawsuit I've mentioned, I suspect our state legislature is going to keep targeting DEI-related initiatives and continuing to try to whittle down their impact here in Florida. Next slide, please. So again, while the Stop Woke Act currently is not enforceable in Florida, I suggest making sure you're familiar with this law and that you prepare that there might be other laws coming out of Tallahassee this year and in the future that really make you not necessarily reconsider your DEI efforts, but make sure that they are consistent with this law and others that you might see, so that if you choose to have DEI-related efforts in your workplace, that they don't become a big problem for you and a headache for you, and that they can have the intended impact that you want in your workplace. All right, so Florida trends and legislation to watch. So 2 things up here on your screen. One thing that we're going to be on the lookout for in the 2024 session is whether the legislature rolls back protections meant to keep 16 and 17-year-olds from working too many hours. For some reason, there's been a big push for this from some legislators in Florida who represent constituents in rural areas where agriculture is the main industry. But there's also been a lot of pushback from legislators in Florida from more urban and suburban areas who are saying, why on earth do you need a 16 or 17-year-old to work an unlimited number of hours? So this has gotten a lot of attention in the press in the last few months as something that may happen in Tallahassee. I suspect this is going to die in Tallahassee as it goes through the legislative process and probably won't make it out of committee. But I do think it's still going to be on the front pages of a lot of newspapers, because that's just what happens to us here in Florida. Somebody proposes an idea that seems crazy, and the press at a national level and here locally love to run with it. So we're going to keep an eye on this, but I don't suspect it's going to have much traction in Tallahassee this year. So something that did happen in Tallahassee in 2023, and we're keeping an eye on, is the elimination of the requirement to have a license to carry a concealed weapon. So this law basically says people in Florida, so long as they meet certain criteria, don't have to have a formal license in order to carry their concealed weapon. And And we think that this is going to increase the number of people carrying concealed weapons here in Florida. And we just wanted to point out that employers, despite this new law, are still going to have the right, as they've always have, to regulate firearms in the workplace, prohibit them across the board from being in the workplace, subject to a couple caveats. So there's no impact as a result of this law on an employer's ability to keep employees from having a concealed weapon at work, or having one that's not properly locked in their vehicle. Employers can still implement whatever policies they want to prohibit the carrying of concealed weapons, including taking disciplinary action all the way up to termination for violating these policies. But one thing this law makes crystal clear is that employers can't discriminate against employees based on an employee's decision to exercise their right to carry or for gun ownership in general. So if this stuff is happening outside of the workplace, maybe there's a posting on a personal Facebook page, or there's a conversation in the workplace about an employee owning a gun or being a supporter of the Second Amendment, this law prevents employers in Florida from taking action and discriminating against somebody on the basis of gun ownership, which is something pretty unique nationwide, and something we're keeping an eye on to see how it trends here in Florida. So Connie, that's what I've got for Florida. I'm gonna hand it off to you to show us the difference between Florida and New York. And like Stephanie said, at the end, if there's time for questions, I'm happy to answer any questions. Thank you.
Thank you again, Andrew, for giving us the highlights in what's happening in Florida. And as you and I have constantly discussed over the years in our working together, that New York is very pro-employee, has a lot more legislation and rules and regulations in place that really limit an employer's ability to do what they want to do with respect to their employees, and they have to be very careful in enacting and carrying out policies and procedures. So there's New York is a very active case. There's a lot going on, and in this last year in 2023, I just want to highlight some of the and that this is not even all of them. I just chose a handful of the new laws or amendments to existing laws that I believe, and I've seen through my own practice in counseling clients and defending clients, that may likely impact their day-to-day and in the way they carry their businesses. So let's begin with the first slide, and this is one of the biggies of 2023 is the limitations on the use of confidentiality agreements in cases involving claims of discrimination and harassment and retaliation. Next slide, please. This is there has been a limitation on the use of confidentiality agreements already, but effective on November 17, 2023, more amendments were added to refine that limitation a little bit more. And that is the fact that you can no longer, an employer can no longer require a complainant to pay an employer liquidated damages in the event that the non-disclosure or non-disparagement provision in a confidentiality agreement is violated. So what does that mean? Typically, when you reach a settlement with an employee, whether existing or former employee, involving claims of discrimination, harassment, retaliation, you do have a provision there that of non-disclosure, and that if you do violate the confidentiality, including non-disparagement provisions in that agreement, then because the impact or the damage to the employer cannot be calculated, there's a provision for liquidated damages and a given amount is provided. that is no longer valid in New York. Any agreements entered into after November 17, 2023 can no longer have a liquidated damages provision. Next slide, please. The another limitation is requiring other separate from liquidated damages, which is usually a set amount, is some settlement agreements state that if a complainant, violates the confidentiality provision, including non-disparagement provisions, that they will forfeit all of the settlement amounts that have been agreed on. And again, under the new amendments to the New York law, you can no longer have that provision. Also, it's typically not my practice. I do have a provision in settlement agreements that state that the employer does not admit to any liability. I have seen settlement agreements, however, that state that the complainant was not subject at all to any form of discrimination or retaliation as alleged. Typically, that comes up in the whereas clauses of a settlement agreement. You can no longer have that affirmative statement saying that whatever the allegations of discrimination, harassment, or retaliation did not happen at all. And here is another big change from the existing confidentiality agreement law. The old law says that you must provide the complainant 21 days, at least 21 days after receiving an agreement to review and 7 days to revoke. The new law changed it to up to 21 days. So any period between 0 and 21, if the complainant chooses to sign it on the 10th day or the 5th day, that is fine, so long as the agreement provides up to 21 days for them to review the proposed agreement. And one of the questions I typically get, we give the draft agreement today, and then they make changes. And so they give back the changes to us, in day 4. Does that mean they get an additional 21 days from that time that they gave us the provisions? No, they do not. The 21 days run from the time that we provide them with the draft settlement agreement to consider. The 7-day revocation period is still in place. That doesn't change at all. One really important provision here. This applies to this whole up to 21 days applies to pre-suit settlement agreements. But if the settlement involves a claim that's already been filed in court, then the law states that you still need to give the full 21 days for the employee or the complainant to review. And again, you only get, and I repeat this, confidentiality provisions or confidentiality agreements, you can only put that so long as the complainant wants it as well. In other words, you cannot insist on it and then give them the 21 days anyway. You have to show that it's also with the express consent of the complainant or the employee who filed the complaint. Next slide. And then the last change or newest amendment to the use of confidentiality agreements is that there's typically a provision that the employee or complainant is allowed, despite giving a full release, they're still allowed to file they're not prohibited from speaking with a governmental agency such as the EEOC or the New York State Division of Human Rights. Now the new provision is that we must include the Attorney General's office to be added to that protective activity provision, meaning you need to list down the New York State AG's office when you are using this protective activity provision in your confidentiality agreements. Next slide. In connection with discrimination, harassment and retaliation claims. For claims arising on or after February 15th of this year, of 2024, the employee or complainant now has up to 3 years to file their claims under state law. So before it was 1 year, and now that's expanded now to 3 years. So you can see how New York really is trending towards more expansive protections for individuals, for the employees. Next slide, please. So best practices given these amendments, well, with respect to your confidentiality agreements, or with respect to handling or strategizing settlements regarding discrimination and harassment claims, it's really important that you review your current templates that include confidentiality provisions or restrictions on reporting protected activities. And also keep all of these time considerations in mind, the provisions for liquidated damages, when you are negotiating settlements. Next slide. Like Florida, New York did increase its minimum wage. Next slide. And that is effective as of January 1. So please double check your pay rate schedule. Make sure that your minimum wage is set at $16 per hour in New York City, and that's the 5 boroughs. That's for those who are not in New York, it's the 5 boroughs are Queens, Bronx, Brooklyn, Manhattan, and Staten Island. So if you have any employees working there, minimum wage must be $16 per hour, as well as the counties of Nassau and Suffolk, which is in Long Island, and Westchester, which is in not quite upstate New York, but north of New York. In upstate of New York, past Westchester, minimum wage is raised to $15 per hour. For home care aides, they have a slightly different calculation. Minimum wage is increased to $18.55 in New York City, and in the counties of Nassau, Suffolk, and Westchester, the remainder of New York is increased for home care aides to $17.55. These wages are set to increase by 50 cents on January 1, 2025. So we're going to go to $16.50. And then in January 1, 2026, it's going to go up another 50 cents to $17. Next slide. Now, there are exceptions, for claims of unpaid minimum wage and overtime requirements. And typically when you get this type of claim, one of the things you look at is there an exemption here? And there are categories of exemption. I'm just going to talk about briefly the salary exemption. And that has also been increased. Effective March 13th, that minimum salary is going to go up from $900 per week, or $46,800 per year, which is the current rate, to it's an increase of $400 to $1,300 per week to $67,600 per year. In other words, if you do get a claim for unpaid minimum wage, unpaid overtime, and you want to avail of the defense of that, well, we're paying higher, and this is again for covered employees, and they're exempt, or they're getting paid a lot more than the minimum wage, you need to look at, okay, how much are they getting per year or per week? And that is the new rate. It's $1,300 per week, $67,600 per year. Next slide. We have been getting a lot of wage and hour lawsuits and claims and complaints that we have been defending. I have been quite busy with this stuff in the last year. And now there's another wrinkle for employers. Can you forward next slide? The new law in New York that was passed it's now a criminal act not to pay wages. And this goes with the failure to pay wages at all, meaning, I've seen this situation where a business is having financial problems, and they opt not to pay their employees for a week or 2 weeks and just bump that up to, the next pay cycle. Well, you already missed the pay cycle and technically you have not paid the wages due. And so under the new law, that would be a criminal act. It would be considered a larceny. So on top of the civil claims, it is possible that the employee can report you to the district attorney's office, and the newly formed worker protection unit of the DA's office can pursue a criminal claim against you. And the standard is bad faith for a criminal act. And so, which means that's also a defense for us. We would have to establish, we meaning the employers would have to establish that whatever it is, whatever the alleged violation is, was not done in bad faith. That also covers the failure to pay minimum wage or whatever the agreed upon wage is. So if you have agreed, if your employment agreement states that the employee is getting $20 per hour, and you did not pay them $20 per hour, you paid them, $16 per hour, that's still minimum wage under New York. That may still be considered a violation because the agreed upon rate was $20 per hour. And it also covers the failure to pay overtime. Just a word on, for those, some of you may already be aware of this, but the failure to pay overtime when you get the lawsuit or the complaint typically includes as well a failure to pay minimum wage. And, it sounds counterintuitive. It's like, okay, we pay them their wages for that week. We didn't pay overtime. That was what they're saying. Why is it that, they're saying we didn't pay minimum wage? Well, the logic there is that if they work 60 hours a week and you didn't pay them overtime, and you paid them for 40 hours, then you divide that 40-hour payment over 60 hours. And if that falls below the minimum wage, then you're technically in violation of the minimum wage provision. Next slide, please. Okay. Independent contractors, freelance workers. A lot of the clients that we have or individuals I speak with typically say, oh, well, they're not an employee. They're just an independent contractor. So they do not get the same protections as an employee, right? Or the same benefits. So yes and no. I'm the whole issue of whether an individual is an employee or an independent contractor, particularly in the gig economy, is an entirely separate webinar in and of itself. But focusing on what New York has done for freelance workers, i.e. independent contractors, there's been several changes. Next slide. The Freelance Workers Protection Act already exists in New York. But there's been amendments as well, and this time it's specifically for expanded to include independent contractors too. And I use those terms interchangeably, but sometimes there is a difference. And this new law will take effect in May, so you have a little bit more time. What is the definition of a freelance worker? They are hired or retained as an independent contractor to provide services for a compensation of at least $800 or $800 over a period of 120 days. And this applies to whether you're contracting with an individual or an organization, and whether or not they are incorporated or employing a trade name. Next slide. There are exceptions. It's not applicable to sales representatives. It's not applicable to attorneys, licensed medical professionals, and construction contractors, not laborers, but contractors. Go ahead. Next slide. What does the new law say? You must have written contracts, and they are to be retained by each party. And as the hiring party, you must retain that contract for 6 years. And you must make that contract immediately available, upon request from the labor commissioner. You need to pay timely. Of course, that is typically a term in the independent contractor agreement, and you have to pay no later than 30 days after completion of the work. And then retaliation is prohibited, meaning if there's any complaint, like an employee would make, they are also protected by the retaliation laws of New York, and they can file a complaint with the labor commissioner or file a lawsuit. So it's very similar to what an employee can do now if an independent contractor has any complaints. Keep in mind too that the harassment or anti-harassment laws of New York do extend to independent contractors, freelancers, and vendors. So this is just more specific, and they can file a claim for a violation of this new law, in addition to whatever is existing or available for them out there. Next slide. So once again, best practices. Review your current agreements or contracts with your independent contractors or freelancers. Make sure you ensure clearly defined terms and provisions. And here's what I like a lot about the New York State Department of Labor. I don't like them generally, obviously, because I'm always against them, because I defend you guys, our clients, our employers, our management. But their website do contain really handy information. They contain model policies for the workplace. They contain model contracts, model notices to distribute to employees. So because this is and especially because this is it's a fairly new law, it's still developing, implementation and its contours remain unclear given its newness or novelty. It's handy to keep track of updates that the New York State Department of Labor may be issuing. Next slide. COVID in the workplace. A lot of the restrictions have already been lifted, as you know. Next slide. New York has the HERO Act, or the Health and Essential Rights Act. And if you recall, this was passed back in 2021 in response to COVID. And it required employers to adopt and implement an extensive exposure prevention plan, which expired by March 2022. So for those of you who have the HERO documents and were diligent in adopting and having all of these documents, you are no longer actively required to keep updating those, but you are still required to maintain it. In other words, do not throw that plan out. Keep it. You have it in case you're audited, and in case somebody complains about it, you do have a prevention plan that's still among your policies and procedures. Next slide. But what was the new law, or the new amendment? As of December 28, 2022, and this is now and this is actively enforced, by the way. The employer, upon the request of the employee, is required to create a joint labor management workplace safety committee within 5 business days of receiving this request from the employees. So you need to create a committee composed of both employees and management for purposes of the HERO Act. And the failure to create that committee within 5 days of an employee request incurs penalties of $50 per day until that violation is remedied. And other than that, I think the COVID-related laws in New York haven't really been that active. Next slide. And I just want to emphasize here that, I'm sorry, the previous slide, please, that this applies to 10 or more employees. So if you have a, if you have less than 10 employees, then, you would be exempt from this law. So what are the best practices? Next slide. Review and update your airborne, your HERO Act, your airborne infectious disease prevention plan. Act swiftly upon receiving a request, and make sure that all your supervisors are trained regarding the HERO Act's requirements. Next slide. I see that I don't have much time left. I'm going to try to breeze through this. And this is a very key piece of New York City legislation. I get questions about this all the time, and consistently, and it is confusing. So I'm just going to highlight certain, like the key provisions of this act. I would welcome any questions that you have. There's a lot of nuances to this particular act. And as you said about working out, especially here in the beginning of the year, the accrued, or if you front load, the amount of time that you should be giving to your employees for safe and sick time. I'd be happy to walk you through the different aspects of this specific act. And I know that it's New York City, although New York State has a similar provision. They are parallel to a large extent, but of course, New York City always tends to be more expansive than the New York State laws. So this amended rules went into effect on October 15th. And just a quick recap, what does the New York City paid and unpaid leave laws require? It's for 100+ employees. If you have more than 100 employees, you are required to pay 56 hours of paid leave for safe and sick time in a given year. And if you have anywhere between 5 to 99 employees, it's 40 hours of paid leave. If you have 4 or less employees, but you have more than $1 million in revenue annually, you still have to pay 40 hours of paid leave. If you have 4 or less employees, but you have less than 1 million in revenue, then you need to give 40 hours of unpaid leave. The safe time provision of this act is quite broad. It covers even going to court or dealing with domestic violence. So it has a lot of components to it, and so be really careful when an employee is asking for time off, because they're not that they're sick, but they want to avail of the safety provision allotted to them by law. So the important part here is the size determination of your workforce. It includes part-time employees and employees jointly employed by more than one employer, and employees on paid or unpaid leave. So if you have a workforce involving 150 people, and 50 of them really are jointly work with another subsidiary that you have or affiliated company, they need to be added together. If you have somebody who's out on disability, they still need to be added when you count the number of employees that you have. Next slide. The remote workers provision is important because given what we do now regarding remote work, including telecommuting. So here's the rule. If an employee is working while physically located outside New York, they are not considered employed for hire within the city of New York, even if you are in New York City. What does that mean? It means that if you have an employee who's working in Florida, okay, but they are working for you and you are in New York City, that person is not counted as part of the employee count. They're not considered working in New York City for purposes of the earnings for the Safe and Sick Time Act. That's a big change, because before this amendment, a remote worker can be counted if they're providing services to New York City and they're providing more than 80% of their work to New York City. That's different now. That has changed. If an employee, however, is living in Florida and is required to go to New York City to work for 1 week every 2 months, and now they technically are spending a lot more time in New York as opposed to working completely remote in Florida, that individual who spends significant times, even though not consistently or continuously, in New York City will be counted as part of your workforce for purposes of the Safe and Sick Time. Again, if you have further questions about this, you can email me. I'd be happy to discuss this with you. Written policy, you must have it. There's always a debate about foreseeable versus unforeseeable. If a person is scheduled to have a medical procedure, then you can ask them to give up to 7 days notice in advance. If someone just got sick, they woke up, they have a headache, the rule is that as soon as practicable, they can notify you. So what methods of notification? Next slide. Not sure if I added it here, but methods of notification can be by text, by email, it depends on what your policies are, a phone call to an immediate supervisor. Those are all ways of reasonably advising or informing the employer when an employee gets sick suddenly. Accrual is another big thing. And you can either give it front loaded, meaning you give them the 40 hours January 1, or they accrue X amount of hours every week. The rule is that as soon as they accrue it, they should be able to use it. No waiting time allowed. You should keep a copy and advise the employee, then ideally it should be in the pay stub, how much time they have left for the year, how much was used, and you should keep all these records tracking down the use of a safe and sick time for a period of 3 years. Next slide. And I'm just gonna breeze through this because I apologize in advance. We're out of time. But prohibition on social media, general rule, next slide. Next slide is that, and this is effective March 12, 2024, an employer cannot now request for an employee to provide access to their personal account, even if it is on a device provided by the employer. However, the employer does have the right to request access to accounts in a personal device issued by them. An employer issued device, so long as that account is business related. Let's move on to the other big thing. This is the limitation and inventions assignments. Basically, I see this a lot in employment agreements where, next slide, and this took effect in September of 2023. Basically, if an employee makes any inventions they make on their own time and they do not use the employer's equipment, supplies, facilities, or trade secret, they are not assignable to the employer while they're employed. All of the assignment of inventions provisions I've seen are written more broadly. This is restricted now, and if it's written in the old way, chances are that will not be enforceable. Lastly, on the trends, I just highlighted one big trend, but do expect a lot of changes this coming year again. This is what we're watching out for. It's the non-compete agreements. There's a proposal to ban non-compete agreements for individuals who are making at least $250,000 per year. But as it's written right now, it seems this $250,000 limit is being debated on. The proposal as is written has no limit, but there's a group of legislators who are arguing that we should have a dollar limit, and that dollar limit is 250,000. So please do, and I hope you do subscribe to the Hinshaw's Employment Law Observer. Our writers, our colleagues here are very diligent in keeping up to date with changes in the law nationally. And that's a blog, the Employment Law Observer, which we distribute to all our clients. If you're not on the mailing list, please, I hope you email us so that you could be on the mailing list and you get them. Thank you for your time and your attention.